Now, this same development occurred in the civil law systems, but in a much more natural way. That is, the term self was not used in the definition of the concept. It wasn't called self-defense, so they didn't have a problem between self and other. They called it legitimate defense. And if it's called legitimate defense, then the criteria of legitimacy determine when you can intervene. Now, you have to think about the implications of this in international law. The implications in international law are that if a state is overrun by an aggressor, we, the United States, have the right to intervene to protect it. We have the right to intervene without being invited to do so. There's a long discussion about the relevance of invitation in the domestic criminal law, and actually in the history of Jewish law. It's actually quite interesting as well. There is an example. This is very important. The way international law now is typically stated, you cannot intervene in a third state unless you're invited to do so. Now, I don't know where that rule came from, and I don't know whether it's a sound rule. If it is a sound rule, it has to be justified. But one thing is clear, it is not an inference that you would make from the concept of legitimate defense. The concept of legitimate defense is based upon the idea that there is a legal order that envelops all citizens in all states, and when you act in defense of that legal order, your conduct is right, and your conduct cannot be the subject of criminal prosecution. Now, you can see if my theory here were followed, we would have an interventionist policy that would be much more aggressive than the one we have now. Thinking of Nicaragua, Kuwait, various places. South Vietnam, there was always a discussion in Vietnam, were we invited or not invited? But according to the principle of legitimate defense, the invitation is irrelevant. You don't have to be invited. The case was decided, a hypothetical case that only criminal lawyers can think of. A woman is being raped on the street, and two guys come up to her and say, shall we kill the aggressor? And the woman says, no, don't kill the aggressor. Does that mean that you consent to this assault? No, I don't consent, but I don't want you to kill him. Do they have to listen, the two guys on the street who are in a position to kill the aggressor? The answer is no. They have the right to defend the legal order whether the victim invites them to or not. Actually, this is a case that comes up quite frequently in wife-beating situations, and we had to go through a long process of development to give the police the right to intervene whether the spouse complained or not. And the right to intervene is based upon the principle that if you are defending the legal order, you are acting in the right, and the invitation is not necessary. Why should it be different in international law? What is the good argument in favor of an invitation policy? Well, I think there is one difference in international law that is significant. The difference is that when you go to the defense of a country that is being aggressed upon, there's the danger that you'll stay. That you'll dig in your heels, you'll set up camp, and you'll stay for a while, beyond the time that it is necessary to avert the attack. This is a slight problem. And avoiding this problem, I think, gives some leverage to the invitation argument. Okay, you can come in to rescue us, you can come in to help us, but we have to somehow assume the risk that you're going to stay too long. So the recognition of sovereignty adds something to international law that the recognition of individualism does not have in the criminal law. That is, the individual victim in criminal law is not important compared to the protection of the legal order. But the individual state and its sovereign authority is still important. And for that reason, the invitation policy requires some resistance to the thesis. The most I can hope for from this argument is stimulating debate about intervention in situations where it is clearly the right thing to do. And we basically are in favor of that. Now let me turn to the second argument. What can we learn about international self-defense by comparing it with domestic self-defense? I've been talking about that to some extent already, but I think I have to go into greater detail. At one time, I think one of the books that William Merkel kindly did not mention was my book on the Getz case, which I wrote in the 1980s, which was a study of Bernard Getz, who shot 4 young blacks on the subway in 1984, and it became the cause célèbre of the 1980s. It's a vintage piece. If you want to understand New York in the 1980s, it was a different world. It was a world of violence. It was a world of self-help. It was a world in which you can understand the necessity of carrying a gun on the subway. You have to read the Getz case, the book on the Getz case. It's called A Crime of Self-Defense. This was a case that tore apart the country because it really was right at the tipping point between the legitimate use of force and the abuse of force. So on the basis of that study, I just want to review quickly 6 elements of self-defense and see how they play out in the international arena. There are 3 basic elements on the side of the attack and 3 basic elements on the side of the defense. The first element is there has to be an attack. Now, the interesting thing is, this is obvious, I think, under international law. There has to be an actual attack, not just a perceived attack. The Model Penal Code is drafted so that if you perceive an attack, the case is treated the same as an actual attack. I don't think international lawyers think that way, and they shouldn't think that way. There has to be an actual attack that is visible to the world. It's not enough to say we have secret evidence that they are attacking us. We believe that they are attacking us. We need, and I think this is one of the great tragedies of our whole history of our involvement in Iraq, what the world needs is clear proof of an attack, or, at least in the case of Iraq, of the possession of weapons of mass destruction. Planning it, something, proof that is available to the world. My model is always Adlai Stevenson showing photographs of the Cuban missiles in the United Nations. Here's proof that the Cubans were engaged in aggressive activity. Something you can show the world that is public information so that the world can understand that the use of force is defensive and not aggressive. This is essential. The attack, it's not a major point, has to be overt. It has to extend into the world. It can't be something that just occurs in your mind. That's a variation on the first point.